I don't know what we're doing with Ask a Lawyer.
Yeah, do we give an intro?
Let's say welcome back.
Hi, we're back. Patrick Daniel Law, ready to answer your questions. It's Ask a Lawyer, Lawyer Live. So Randy and I are here to answer your questions that you've either sent in, are currently sending in, are ready to send in. Under any circumstances, we are ready to answer those questions. So let's go straight to it. Our first question is from
Wagon _force asks, what are your opinions on the protesters protesting stay-at-home orders?
Randy. I'll let you take the political action question first.
Sure. I think obviously most people know that we have a fundamental right to protest under the Constitution. So I think that they're exercising their rights to do so. I think that both sides of the coin, it's difficult because there's evidence that supports both decisions. On one hand, we have people that have an interest and are trying to make sure that we stay safe. They're protecting the public at large. They don't want for people to get sick. But then on the other hand, of course, we want the economy to do well. Many people are losing their jobs. They're in despair. Many of the states' unemployment offices are completely overrun with work. So it is a very tough balancing act. I don't feel for any of the governors in any states to have to make this decision. I was talking to a good friend about this last night, going back and forth on the pros and the cons of opening versus keeping things closed. And the data is so arbitrary, really, when it comes to, if we stay closed longer, what's the cost benefit analysis of that? I mean, is the cost of it greater than what the benefit is? And I really don't know. So I don't feel for them. But to answer your question, I think that these protesters, anybody has a federal constitutional right to protest. Hopefully it's peaceably, and so that people and our government knows that there's pros and cons to both sides, and hopefully they weigh those out, accordingly.
Yeah, I mean, I agree with you 100%. Obviously, the First Amendment grants you the right to assemble.
Correct. Yeah.
Free assembly. Obviously, you have the right to free speech. However, do so intelligently.
Yeah.
I mean, all of the displays that I see and all of the protesting that I've seen thus far has people, half an inch from each other. There's 700 people. Nobody's wearing a mask. I realize people want to get back out and get after things and make the economy robust again. But one of the problems is Georgia's governor last night, for example, wasn't even aware that coronavirus could be passed in an airborne fashion previously, as well as not aware that, for example, it could be passed. In other words, you could not display symptoms, still be a carrier of the coronavirus, pass it without symptoms. I think if you're going to engage in a protest, which is your right, whether we agree or don't agree, we don't really have an opinion one way or the other. I think you got to do so understanding all the facts, understanding how to protect yourself, understanding more importantly, maybe, how to protect other people. Because while you're out there protesting and exercising your rights, you don't want to expose others. And that's important. Otherwise, you could be in a negligent situation having passed the coronavirus to someone. So just do so safely. Next question.
We have from Trinity 3560 ask, is it legal for the president to suspend immigration in the U.S.?
Yeah, I'll take this. First disclaimer, I'm not an immigration lawyer. We have people that we can refer you to. So if you want to call, I can certainly refer you to a good immigration lawyer. Our motto always has been, if we can't help you, we'll refer you somebody who will. What I would say from this perspective is that the Commander-in-Chief is empowered to do any number of things under the enumerated rights. However, there are certain clauses that allow him, and generally reserved for war times, but other times, and they've expanded the enumeration of powers to include the presidential power to do certain things like shut governments down, shut the borders down, anything for national health. Now, it's going to be the sort of thing that you rest assured will wind up at the Supreme Court here in a real short order being challenged by someone. So you will get a definitive ruling on exactly how that power is going to be interpreted from an immigration perspective. I'm not saying somebody's already filed something, but mark my words, I would think within the next week someone will, if he is in fact shutting the borders down. The easiest explanation that somebody can give is his power is vast under issues of national health and issues of a national crisis. Randy, you have anything?
Yeah, I would say I think that's exactly right. I think it will go up on cert, and they'll accelerate it, is what it's called. We sometimes see that when there is an interest that has to be decided quickly. Everybody knows in Gore versus Bush in 2000, the Florida, Chat County, that's one example of where the Supreme Court took it up on cert immediately. I think this is one of those situations. I would go so far as to say that the more conservative Supreme Court at this time will decide that he is allowed under the enumerator powers that he's given to make that choice in the interest of national health and security. But I think it will go up, and I think the Supreme Court will determine that he does have that power to do so.
One thing for those of y'all that Randy made a pretty good point when he referenced that the court's very conservative now. For lack of a better explanation to give people on how the Supreme Court and how the federal courts are basically filled, is it's a lifetime appointment, and it's an appointment by the President of the United States. So while there is the separation of powers between the three branches of government, the President is effectively in control of appointing federal judicial nominees to the district courts. They are moved up to the circuit court positions as well as to the United States Supreme Court. And Randy, correct me anywhere along the way here if I've screwed something up. But the reason it's so important is when someone is elected president, he effectively has control over the political balance of the court system. And that's why you'll oftentimes see a Ruth Bader Ginsburg or an older justice not retire until a new election, hoping that the seat's going to be filled by someone appointed by a judge that is in their same political party. It's interesting because, I'll be frank, I think it feels like Trump has filled more open positions than virtually any president I've seen over the course of the last several presidential terms, which is important because you're able to accomplish a lot more when you have a politically swayed judicial system. So Trump appointed Kavanaugh, is that who he said?
Yeah, Brett Kavanaugh was the last, and then
And
there's two more before.
so as they get older and they sit there with a lifetime appointment, it's the sort of thing where you have a heavy ability to sway decision making in the country in a separated branch of government. So it's something that everybody ought to really think about when they do elect a president, is you're effectively having some control over the court system as well contemporaneously. There's no guarantees in life as to how they're going to vote, but their political affinity and their voting history, if they have been in a previous district court position or a circuit court position of some type, is going to play pretty heavily into when they get moved up to a Supreme Court position. And as a consequence, like Randy said, you have a conservative court right now because Trump has been pretty effective at carrying his weight with the court system on the federal level at this point. So who do we have next?
We have a question, a write-in question from Wisconsin. So I have a question. With all of this quarantine BS, I've had 2 extremely important doctor's appointments pushed back already because the tumors that I have are not deemed essential. Are you effing kidding me? Now I'm sure they will get pushed back even though hospital staffs are being cut. So this will potentially be bad for me. These tumors could be doing more damage the longer they sit in and take over. But I guess I'm not important enough. So anyone out there have any suggestions? Should I contact an attorney? In this case, I'm very pissed off and frustrated.
Sure. I don't. Did she say what her name was or no? Nicolette?
Yes, her name is Julie Jasper, and she's
Okay.
in Wisconsin.
Julie, first off, we're very sorry to hear about that. I think that in your situation, my advice to you would be is to contact that doctor's office. If not, you can always attend or go to an ER and complain about this, because any emergency room is going to be open. Hopefully they would be able to refer you to a doctor to have it looked at immediately. anytime you go to an ER, they're going to probably have some diagnostic scans done, but they would be able to refer you. Now, with HIPAA being lifted, we're now able to see doctors. I'm surprised if you've called your doctor's office and they haven't been able to see you either telephonically or through Zoom or through FaceTime or something else, because that's allowed now. I would really encourage you to do that if you have a historical doctor that's been treating you for this. If not, my recommendation would be to go to an ER facility where they can examine you. They can take a look, because if there's something that's immediate that needs to be tended to, that's the place to do it. If not, they'll put you in some sort of urgent care and send you to another physician that would be able to monitor, diagnose, maybe even if you have to have some sort of treatment or surgery. But tumors are no joke. That's something, especially if it's cerebral, that you want to get looked at immediately.
Right.
I understand your concern and frustration. But there's some avenues there for you to go through to make sure that you're getting a look at this, because it's very serious.
Is this something that you guys do, and or should she contact a lawyer? Is this a lawyer time?
Well, I don't necessarily think it's a lawyer thing to do, unless there is some sort of injury that you have, unfortunately, because as personal injury lawyers, we, right now, I think the best thing for you to do would be to just call the ER or the doctor and go. Now, if it results in some sort of injury, we do personal injury work or medical malpractice work like that, but there has to be some injury that occurs. It's horrible to say that, but it's not something that a lawyer necessarily would facilitate, but it's something that a lawyer would litigate if there's damage that results.
And do you
from it.
practice in Wisconsin?
Yeah, I'm licensed in Wisconsin. But I mean, I think when you say tumor, I think it's a little bit vague. I think it's the sort of thing that we need to know: what is your actual diagnosis?
Sure.
That the tumor's been identified as malignant or benign. Do you have a prognosis of some type? Is there a spread of the disease at this point that you know is ongoing? For example, have you had radiation treatment suspended as a byproduct of this? Or is it the sort of thing where they've unilaterally decided to suspend your radiation treatments? Those are actionable.
Right.
I mean, those are instances where you have medical malpractice where they could unilaterally do something to intentionally injure you or some type of meaning. It's just, it needs to be a little more specific than that. If you want to text a little bit of additional information, Julie, we're happy to kind of answer it with some more specificity. He's right. Sadly, the nation is on lockdown, as Randy pointed out earlier, and as we answered the earlier question, you are effectively at the mercy of the government to a certain extent to protect your sisters that are out there. So as a consequence, we are dealing with a situation where it's going to be, even if actionable, potentially less actionable than it would be under normal circumstances, because you're effectively under medical martial law at this point.
We have another question from Dina D. I have a friend who started a legitimate nail clipping business out of her home for dogs. Her local dog hospital is allowed to do it as well. She had the police called on her and they had her shut it down, but when she asked them, they could not answer if it was if what she was doing was actually legal or not. They replied that they did not know. When she spoke with the local politician, they could not answer her either. Can she really get into trouble if no one is sure if it's an essential job?
Is this a Houston question?
This is also a Wisconsin question. We have a lot of fans in Wisconsin.
Yeah, I would say the first thing out of the gate is how she's zoned. I mean, if she's not zoned to conduct a business out of her house, she's already kind of stepped in it, for lack of a better analogy. You've got a situation where if she's zoned correctly and able and licensed to run a business out of her house, she's crossed the first hurdle. Essential businesses are defined state by state and federally. For example, I haven't seen anything that says law firms, for example, are allowed to conduct themselves as a federal essential business. But the state of Texas has identified that we're essential. We need to look and see what Wisconsin defines as an essential business. And if it's the sort of thing where you want to consult and obtain a legal opinion on whether you're defined as an essential business, you should do so. My gut tells me that nail clippings for dogs are probably not an essential business. I don't know if that's the totality of the scope of the business. or if there's more to it. But again, you want to give us some additional facts and come back and ask us some more questions, we're happy to answer. And we want to remind everything that the topic today is ask us your legal questions. This is like, I don't know what we've termed it at this point. It was the legal lens. I kind of vetoed that. I'm not really sure if that's my favorite, but it's Randy is a law dog. What you can call him.
We have a question from Charles in Texas. Does an employer have the right to make someone go to work with or without a mask?
Have the right, or can they simply require it? I mean, you're a private business owner. You've got the right to do a number of different things, whether enumerated or otherwise. Also depends on potentially whether you have a contract. But first and foremost, why wouldn't you want to if you have one? You don't want to spread the virus to other people. I mean, I think one of the things that the employer is probably looking at doing is attempting to insulate themselves from liability. Now, if it's the sort of thing where they're telling you don't wear one,
Right.
I think that's kind of a problem. Randy, what are your thoughts?
Yeah, I think the same. But I think sometimes when people ask this question, I know we get this question a lot in the employment context. What I sort of tell people is say, can I be terminated if I don't do that? The answer to the question is yes. In Texas, as in most other states, frankly, or at will. So unless you have a contract for employment that specifically sets forth the reasons for termination, for example, if you're a teacher that works at a school district, or you have a contract for employment, you're an actor, you're at will. We could fire our legal assistant because she's wearing purple shoes today. You can do that, but what you can't do is terminate someone based on a federally protected class status, or if the organization has additional protections for people that aren't protected. So they can't fire you because you're a male. They can't fire you because you're Jewish. They can't fire you because of your national origin. But they could potentially terminate
Sexual
you.
preference.
Yeah, correct. If you choose not to come in based upon the order. Now, would you have a potential right to file a claim later? Maybe. We would need to have more information. But to answer the question as worded, do they have a right to do that? Well, they're a private business. They have a right to make sure you come in when they want. And if you don't comply with that, you can get fired. But if they do that and they purposefully expose you or recklessly sort of expose you to an environment where you would potentially be sick or succumb to the illness or get the virus, then there's potential negligence claims that can be pled against them if in fact you do get sick and if in fact it results in damages. So I think your question spawns off a cascade of issues that we would need to have more information on.
Yeah, absolutely. I mean, I think Randy clarified things very well there. Federally protected class, but I mean, you have to keep in mind your employer is protecting themselves in order to not be exposed for exposing you to the coronavirus if they're telling you to wear a mask. I don't think any jury is going to look at that, even if it was actionable, going, oh my goodness, how unreasonable this employer to want to protect your coworkers.
Yep.
We have a question from Elizabeth in Texas. She wants to know, what does it mean when you hear that an issue is going to the Supreme Court on cert?
Okay. So she's from Texas, you said?
Yes.
Okay, so in Texas we have really different tiers of courts. As trial lawyers, we take cases to either district court, municipal court doesn't really happen, but sometimes it happens, and county courts of law. If we try a case at county court of law or district court and there's an error, it's reversible, we would apply for an appeal to go to one of the appellate courts in Texas. Okay. Now, if there's also an error there, then we could potentially apply to go to the Texas Supreme Court, and it goes up on what's called certiorari. And in that, if the court grants cert, then they take a look at the case and determine if the appellate court erred in what their findings and rulings were. So that process takes years. I mean, as trial lawyers, we try cases to district and county courts, mostly district, and that's at the state level. In the federal level, we go from federal district courts. In Texas, we have 4. Or then we go to the Fifth Circuit out of New Orleans, which is several states in the South put together. And then from there, we go to the U.S. Supreme Court. So, but if we're in state court, we go district, county, up to the appellate courts, and from there we go to the Texas Supreme Court.
People should understand you have the right to an appeal as a matter of right, but there is no right for an appellate court above your first tier of appeals to hear that case.
Right.
In other words, the Supreme Court, state or federal, doesn't have an obligation to hear your case. They honestly get to pick and choose what they hear to a certain extent. And it has to be, there are certain criteria that they measure against the issues in your case to figure out if those are issues that are important enough for them to hear.
Yeah.
You know, whether it's a change in the law, whether it's something that affects the community, it's those sorts of things. So keep that in mind. But you have the right to appeal it to the first appellate court as a matter of law.
Right. It's very rare. It's a small percentage that goes to either the Texas Supreme Court or even the U.S. Supreme Court's even more rare. It's only a handful of cases. And it's usually something that hasn't been decided before, or there's a very strong interest in interpreting the law because there's sometimes a conflict of laws. What else we got, Nicola?
We have Grace Morales, and she asks, why are individual states filing lawsuits against China in response to the pandemic? Is that legal?
I'm not sure what states have been filing suit, but my suspicion would be that the allegations are such that China, I mean, Randy, correct me if I'm wrong here, it's got to be a situation where China's concealed, according to the Trump administration, the actual exposure and what their citizens were suffering from in order to deceive the United States and ultimately the states from travel into their states, for lack of a better way to say it. So, for example, they were traveling into Atlanta Hartsfield Airport from China or Beijing or wherever it may be, and there was a misrepresentation relative to the actual level of exposure and whether or not it was safe. Yeah, I mean, if you got some facts.
Missouri did it today.
Well,
So we had
I
someone.
think maybe Patrick's right, but maybe we're trying to interpret the question, and I interpreted it actually a little bit differently. And there are I've seen a couple of lawsuits, I think, where there are groups of people that are filing against China itself on behalf of certain individuals. So it's when you say the state, usually in that case, it's the state attorney general that's filing on behalf of a group of people. Most governments have immunity. So, if you file a lawsuit against a county,
It's a campaign of deceit.
Okay. Yeah. So most governments have immunity. If you file against the county or the mayor or the state of Texas or the U.S. government or another government, there's certain exceptions to that, and one of them is what's called the Tort Claims Act. So the Tort Claims Act, if you're filing against the United States, I've done this before. I've filed lawsuits against the USDA and the USDF and a bunch of other government entities. We're actually filing one against a university, against Texas A&M. But there's also what's called the Alien Tort Claims Act, where you can actually file a lawsuit against another country or their actors if they committed certain crimes, if they committed certain torts.
Yeah.
So it usually has to be some sort of government actor, and there's certain exceptions. In this case, if there was fraud that was committed, if there was negligence that was committed on behalf of a certain person, that affects a bunch of people, that results in injuries. For example, one exception, the three exceptions in Texas are if somebody is driving a vehicle or they're involved in a motor vehicle accident and they work for a government. Another one is if there's a premises defect that results in an injury. Another one if there's sort of an intentional tort that happens on behalf of from a government actor affecting someone else. So that is what's occurring in this case, where we have certain governmental actors from China that I think we're failing to disclose or committing fraud. And that is resulting in people here, obviously, that are getting injured, that are requiring hospitalization, and that are even dying as a result.
Apparently, the article that I read said it's a stunt by the governor to protect his citizens because most of the causes of action, it appears to be fruitless because you have to understand, when you enter into these various national treaties with other countries, you waive a number of causes of action that you have. It's kind of why war exists ultimately.
Yeah.
The sort of thing that you're dealing with here, I personally think your better causes of action are against Delta Airlines, for example, for shuttling people into Atlanta
It's true.
from
It's true.
somewhere
Well,
overseas.
Until they
Now,
file
granted,
bankruptcy.
right, and then they'll have to, basically they'll have to third party in the Chinese government or
Right.
whatever entity. See, the thing is, there's going to be some third party ultimately, in my opinion, that did the due diligence on behalf of Delta
Mhm.
or on behalf of one of the federal branches of government to confirm or deny or ultimately say that everything was safe for there to be travel. I mean, Trump, I think, wasn't just relying on the opinions of his constituents. Somebody went out there and had to conduct a study and had to conduct due diligence. Those are the actionable entities that did these sorts of things for negligent research, for lack of a better way to say it. The real question becomes, at that point, are they going to be protected under color of law because they're acting on behalf of a governmental entity, and governmental entities historically are protected because you are acting within the scope of your authority as a governmental entity, and those governmental entities are protected for what's called discretionary immunity. They also have sovereign immunity. The discretionary is called qualified, but
Mhm.
it's a cascade down of unlimited governmental protections is the short answer.
Okay, we have another question to kind of change some gears. After an accident, what are the steps you should take after contacting the police? Should I agree to not call the police if the driver says he will pay me the repairs?
No. I'll answer the second question first. Absolutely not. This is a great question. I wish that more people would ask it. When my friends and I used to get together on the weekend and have dinner, like we all did at one point, this is something I tell them all the time, family members. Okay, great question. First thing that you do is I do not move the vehicles unless it's in a place that's unsafe to do so and you need to move them out of the way. But if it's a street where there's not a lot of action, I would get out of the vehicle. If you can, unless you're injured, take photos of the scene, take photos of the ground, the points of the vehicles until that happens. Yeah, I do. I want a full accident recon because this is important. What always happens, folks, is people are nice at the scene, the person that hurts you. They say, well, let's take care of it at war. They're going to change their tune because as soon as they speak to the adjuster of their insurance company, their adjuster puts poison in their head saying, because at some point they realize, they get scared that their premiums are going to go up, that they're not going to be insurable at some point. So take photographs, exchange information. You tell that person they cannot leave, that you want police to get there unless they're threatening you.
Photograph their license plate.
Absolutely.
Get their license.
Yeah. Get all the information. Take photographs of that. Tell them that you want to wait for police to get there because, in fact, if they leave the scene, that is both criminal and there's civil penalties as well. There's a cause of action for that, and there's a criminal cause of action for that. But you want to make sure then, I think you call us, you call a lawyer so that we can ensure that we guide you through those steps. If you're injured, I want you to go to the local hospital. And people think that they're not injured. You have to understand you've been in an accident. Your adrenaline level is through the roof. You don't feel injured yet. You haven't had that lactic acid buildup. Your body hasn't settled into pain. It will, no matter what. Give it 2 days and you're going to feel like a train hit you because that's what's going to happen. That's what the body does. You go the same day in an ambulance to the hospital. I don't care how minor of an incident it is. You have them check you out. You have diagnostic tests done, x-rays, make sure there's no broken bones. Tell the doctors you want a referral to a physical therapist. If they don't do it there, the next step that you do, again, you call us. But if that doesn't happen, then I want you to go to your primary care doctor, have them check you out. And then the next step will be either some sort of physical therapy, chiropractic care. We go from what's called conservative treatment to more aggressive treatment as time goes on, and the modalities show that supports it. But if you have a lawyer, we'll guide you through that process. You want to make sure that you secure the vehicles. Don't move anything on the inside. Don't change seat belts, move things around because that's important information to know. We do a lot of product liability cases. I've done a lot of tire cases, seat belt cases, glazing, airbag cases. If the airbags are deployed, we need to take photos of that. Do not do anything with your vehicle. Take it to a secure place. don't change anything. If you can put it in a garage, do so. If not, put a tarp over it so that that evidence is secured, because if it's a serious injury, you could potentially have a product liability case. And those would frankly be best cases to have, because not only are you able to sue the party that hits you, and a lot of times those people just have minimum liability policy limits. We're also able to sue either Ford or GM or Toyota or Takata, who manufacture the airbags or the side airbags, or anyone that manufactured the I mean, there's a million different things that we can do. But if you don't do that, one of the most heartbreaking things I have to do is two things. I always discuss people that have valid medical malpractice claims, that there's this thing called tort reform that eliminates it. But then the other thing is when they have not secured the vehicle and they let the insurance company, you have destroyed your case.
Yeah, do not give your property rights to the insurance company until you consult an attorney to make sure you don't have a property damage claim. Happened with a kid that got ejected from a car 2 years ago that came to see me. They threw away the car seat and they threw away the vehicle. No claim.
Yeah.
It just doesn't work that way.
That's awful.
So Randy's point's really well taken. The objective is to preserve all of the evidence available to you. Any attorney that, in my opinion, is the type of attorney that you want to represent you will gladly pay the fare to store the vehicle for any period of time while they're investigating the claim. It's the risk of doing business. It's what we do. So don't think you're going to be the one holding the bag on those sorts of things. Your insurance company has a duty under the law for at least 30 days to adjust the claim, pay those sorts of fees and fares and expenses. So Randy's point's really well taken, and I wish more people heeded it. More people leave the scene of the accident, don't think they're hurt. 2 days later, they're hurt. They don't do anything about it. All of a sudden, the insurance company, because the first thing that you're going to hear if you later make an injury claim is, well, you couldn't have been that hurt. You didn't go to the doctor the day of the accident, or you didn't go the day after the accident, or you drove yourself, or whatnot. Protect yourself.
The other last thing I'll say about that, because this is really important and everybody fails to do that, whoever stops by or whoever, get their card, get their information, because these witnesses are so important to our case. It's always, especially if it's two vehicles involved, and it's one person, another person, it's a swearing match. Cops show up, it's an hour late. They don't have enough evidence. They just say, they don't put fault on anybody.
They're not a witness to the accident, so they can't testify.
Correct. So if we have witnesses that are there, get every single thing that you can. Because you have to remember, people move, their cell phone numbers change. So address, phone number, get their social media, get their email. Especially email and social media, I have found over the years have been really helpful to people that do that, because that doesn't change as much. Phone numbers change, people move all the time, addresses change.
Yeah.
But a full name for those people, because we will call them, we will find them, we will depose them, and those are the people that can make or break your case when it comes to what's called the liability of your case. The juries love them because they're impartial. Joe Blow doesn't know who Karen is, and Joe Blow 2 years later comes back and says, yeah, it was Mike that completely hit Karen, and he was drunk, and I saw him texting his girlfriend or whatever, and he had a blindfold on in the car, whatever. None of that will come out but for that independent witness. So you've got to make sure you get as many witnesses and their information as you can.
Yeah.
We have A&G McWiggy, also from Waukesha, Wisconsin. She wants to know, my business was shut down. I am essential under pet daycare and boarding. However, what they're saying is the services I provide on top of that are non-essential. What can she do?
And are you asking for creative lawyering, or are you asking for, because I would start checking everybody in under a different name and not just nail clipping.
Right.
I'd start checking people in under board.
Yeah. I'm curious. What you may want to do is maybe reach us, because I'm curious what that statute looks like that would subsume the fact that you're considered an essential service.
I think pet grooming it is in Texas.
Boarding.
I thought we were.
Well, it's boarding.
Oh,
That's
boarding.
the biggest thing,
Okay.
is that
I know, but
she
the
says
services
boarding.
she's referring to are, she's only limited it for the scope of this question to the nails,
No,
and they can't.
this is a different person. This is A&G McWiggy. My business was shut down. I am essential under pet daycare and boarding. However, they are saying she's essential underpaid here.
Well, then I think, and Patrick, correct me if I'm wrong, I'm sort of being creative here, I guess, that if it falls under the statute, if what you do, the boarding falls under the particular statute, they shut you down, first thing that you want to do is make some sort of record that you're trying to appeal the fact that you were shut down.
I wouldn't know who shut you down.
Yeah, I know. I'm curious about that too. But then essentially what you would do is determine what your damages are from the point that they shut you down until you're allowed to be open again. And so that's your damage model. In lawyering, what we always do is always look for two things: liability, who's at fault. In this case, we determine what entity is at fault for shutting you down. Number one, if they have the power to do that or if they don't. And if they did incorrectly, then they're at fault. Then what we do is look at what your total damages are. So we'd have to calculate what your damages are from the time that they shut you off until the time that you're allowed to
She
operate.
said law enforcement shut me down.
Okay.
They called me and told me I had to stop my business.
Called her?
Called you?
Did you record the phone call? I mean, I'm sure you didn't. I mean, I would. I mean, one, I would hire an attorney.
Yeah, I would in this case.
I would reopen.
Yeah.
You know, if there's I would file a petition
Mhm.
if they in fact came back and attempted to shut you down.
Is this something you guys do or
I mean,
no?
it's correct me if I'm wrong. I mean, if you move back in, and it's coming. I mean, I don't know what the statute would cover relative to
Yeah,
this for
it's a
Wisconsin.
weird
My
one.
curiosity was, you're acting under the scope of authority, but it's going to be a violation.
Yeah, it's interesting because I think
This is
Yeah,
not one
she
that
did
I think-
record everything.
Ooh.
interesting. Sorry.
Yeah, I mean, my thing would be, they're acting under the color of law, which you have a statute that they're not following that's in
They're
black and
violating,
white,
Yeah.
and you're going to end up with a civil rights claim after that.
Yeah, because
Your civil rights are being violated for shutting your
God, I
business
mean,
down in violation of the governmental directive.
did they have immunity?
That's my curiosity. I don't know that they have immunity, despite the fact that it's a discretionary act, because it's such a flagrant violation of a very
Mhm.
clear
Mhm.
statute.
Yeah,
Like
they
if-
may not.
if
There
her
may be a
business-
waiver of that because they
If
interpreted it wrong.
if the business is specifically enumerated in
Mm-hmm.
the essential businesses statute, it's non-discretionary at that point.
Right. Yeah.
I mean, it's the sort of thing where if you want some help, I think actually it could potentially be actionable. So call our office if you want some help or some further guidance. It's the sort of thing that I think is a little bit more involved than you initially think, but I would want to see the essential businesses statute and what the governmental directive was from the state of Wisconsin. Because if it actually enumerates your business, then I think they've got a problem shutting you down that I think will ultimately be a civil rights claim against law enforcement, which carries punitive damages if you file it in federal court. Correct. Doesn't carry punitive damages unless it's enumerated by statute in the state court. You can file it in state or federal court, which is usually in federal court.
What kind of claim would she have? Like,
Civil rights violation.
okay, is it something that you guys do, or would you refer?
I mean, I'd want to look at it.
Okay.
We can take a look at it.
So, okay, who's next?
Who's next?
Okay, so she said, "Thank you so much. I will definitely call."
713-999-6666. Patrick Daniel Law, we're here to help. Law dog.
What if? Okay,
Perro de ley. Yeah, it's Spanish. We speak Spanish too. Yeah.
what if I was reinfected? This is Amanda. She's in Texas now. What if I was reinfected as an essential employee? Who can I hold responsible?
Well, that's okay. So you were infected, you recovered, and you were reinfected as an essential employee.
But here, so we have these cases. There's the first thing that we think about is what's the causation? Who infected you? I mean, so
Yeah,
if you
it's-
were infected at home by your boyfriend, you can't sue your boss. So there's
But
on these
All
cases,
employees should probably
right?
sue their boyfriend.
You're employed to sue your boyfriend and maybe you do.
Yeah.
But so in these cases, the tough thing we call causation. I mean, where there's an injury that you have, but who's responsible? So is it plaintiff, you, or us that represent you, we have to prove how you were infected and who's responsible. And if that party was negligent and they didn't exercise reasonable means to protect you from that infection, even if they have a duty to do so. If you're at home and boyfriend infects you, I don't know if you want to sue him. I mean, I don't even have any money to do. But
Workers' homeowners policy.
yeah,
Probably.
well, you would have
I
to be
don't know.
named. You have to be named, but
No, you really.
and she was, yeah,
He'd be a resident,
president.
but not a relative. No exclusion.
That's true. Maybe.
Might have.
But then, I mean, it depends on, again, what your damages are as well. But if you're looking to sue your employer, because that's what I think your question is intimating, we would have to prove that you were reinfected in the workplace and that there was no other, maybe you live at home by yourself and you've completely quarantined yourself for a month except for being in the workplace. There was someone else in the workplace that we found was infected and you were infected as a result. Then we have a stronger causal link for that. And if we can also add that your employer maybe was aware or failed to provide any sort of equipment, or they knew that this other employee was sick, or they failed to test, then you have a potential negligence case against your employer.
It's probably going to be comp. I mean, you're injured in the work environment. The real question would be, was there a duty beyond that your employer intentionally ignored to get beyond? I mean, if they knew that this person that got you infected was sick and they were allowing them to work, which I can't fathom anybody.
Yeah, here's the thing
continuing
that the way work comp is, folks. So Texas, like most other states, whenever you're injured or you suffer some sort of ailment in the workplace, if your employer subscribes to what's called workers' compensation, you're barred from suing them because under the comp policy, you're afforded to go to doctors, potentially psychologists, surgeons, whatever, under that policy. So they send you to the doctors that are in network under that comp policy.
And it's recovery without fault. You don't have to prove anything. You just have to prove you got sick or injured at work.
So therefore,
did it.
Yeah, in order to sue your employer, there's a couple of very small exceptions. One of them is there's gross negligence, but it has to be intentional, or it has to be, really the standard is like they intentionally, like they intended for you to get sick, like they did it purposefully, or it's just so flagrant that there was no other way, there was no other result that could have occurred except you getting sick. I have a case right now where actually this is at play and it's going to be interesting, but I think in the case that we have, the behavior that the employer set forth was so egregious to have this 17-year-old worker up 70 feet in the air without any fall protection, without any guardrails at all on this tiny little 24-inch scaffold. I think a jury would find that is just, there is no other thing that could result but for this guy falling 70 feet. So it has to be something that is just complete. So maybe in your situation, if you work in a tiny little office in a tiny cubicle with 3 other people that were like deathly ill and they made you report to work, then maybe we would have a case where I could stand in front of a judge and say, Judge, there was nothing else that could have happened to this poor girl but for her to get sick because there were these 3 other people that were sneezing and coughing and like touching her kind of deal.
Well, you're going to have medical.
It's a tough standard.
Yeah, and you're going to have medical causation issues from this reinfection. I mean, one of the issues that's being experienced with a number of different people is they go in, they test negative, or they test positive, they later test negative. Some of these test results have been identified as inaccurate, not truly accurate. They're going to bring in an expert to say the error rate of the testing is X.
Right.
And
it's expensive.
It's going to be a situation where you had COVID-19, you allegedly recovered. I want to know how you felt like you recovered because it hasn't been going on that long for you to have recovered and then immediately begin to be reinfected. I can tell you right now that if I was defending the case, your timeline on your activities from the time of initial infection, alleged initial infection, to the time that you were going back, I mean, I would chew you up and spit you out.
Yeah, I'd find.
I mean, you would be using, where'd you go get your toilet paper?
Right,
Did you go outside the house? Did you go near a trash can? Who touched your trash can?
I would, yeah.
I mean, it would be.
I would look at your Instagram, your Facebook to see where you've been, who you've hung out with. your credit cards to see every place that you went to. And I think it's all discoverable and relevant.
Absolutely.
Text messaging to see, oh, hey, I'm on my way over. I'll see you in 15 minutes. And you went to a little party and there was 10 people there. I mean, there's a lot of ways to
No
slice
mask.
away. Yeah,
No
there's a
mask
lot of
one day, no mask another
yeah, there's
day.
a lot of ways to slice and dice that case.
Yeah.
Unfortunately,
It's going to be
it's tough.
problematic from a recovery perspective, simply because it's going to be inordinately hard to prove where you were actually infected. That's going to be the hardest part. And they're also going to throw at you, well, you didn't really ever recover. Like, we don't know currently, I don't think the current state of the science identifies that your body ever truly eradicates itself from the virus or the infection permanently.
Yeah.
Are you always a carrier? Are you now predisposed to it? Do you also have the third party in where you originally got exposed? I mean, is that how you're going to defend it?
Mm-hmm.
I mean, I just know how I would defend that case. It would be nasty.
There's a lot of words, yeah.
Yeah.
What else we got?
So we have a question on Instagram from Justin Kurt. He says, "Hi Patrick and Randy. What is
Justin or Jason?
Justin.
Mm-hmm.
Okay.
Okay.
Hi Patrick and Randy. What is your favorite sports team? And I'm curious on what are your thoughts on the Astros team sign stealing scandal, and now that the Astros owner, Jim Crane, is stating that he can't be sued because the MLB exonerated him."
I would say that's a multitude of questions. First off, let's be real clear. The New Orleans Saints. All day. Because I'm from Louisiana.
I was born and raised in Texas. My parents are crazy Cowboy fans. There's
So is my mom.
no one that I'm like completely impartial to, but I just feel like it's just a family thing, and I'm obligated to say that, Dad. Okay, go Cowboys.
I agree. My mom just thinks
They're
the world with you now.
nuts. Like every Thanksgiving, we were there. And anyhow, okay, Cowboys, go Cowboys. All right.
You know, the second part, first off, as far as sign stealing scandal goes, I'm not going to weigh in on that because I am an Astros fan. I don't really love what they did, but if anybody wants to truly walk in and go that every major league team has got clean hands,
Yeah, sure.
I fail to agree with them on that. However, the last part of it is the legal question
Correct.
as to whether or not the Astros and Mr. Crane, who's a very nice man, are, I guess, immune would be the correct term from suit.
Yeah.
I don't know that. I mean, by who?
Yeah.
You know, I mean, the causes of action are effectively by other teams. The MLB hasn't really, in my opinion, there's no judicial ruling exonerating them.
Correct. Yeah.
So a court of law has not exonerated them and made them immune. Now, if there's a settlement deal, and see, this is where it gets sticky for me because I'm not an entertainment lawyer, despite my family's history. I'm not sure when it comes time for the fines to be levied against the major league team and the suspensions to be entered, is that a contract of settlement that ultimately is documented and papered in the same way as a settlement and a
I don't
judgment?
think it is.
I don't think
Yeah,
it is
I don't
either.
think it is,
Because
yeah.
then, if it is, yes, at that point, I would think there's some immunity. However, is that settlement agreement? Let's assume for
Or
argument's
at
sake-
least res judicata, or
Right.
it prevents a civil suit because there's similar claims that have been adjudicated. But I don't think they're not properly adjudicated. It's sort of like a private party determining, you're a boy, slap on the hand kind of deal. But that doesn't necessarily parlay or in court, the real court of law.
Right. And
So there's other claims that other teams can have, and those are civil claims for damages that they would have against the Astros. So I think the question of whether the MLB, if they can do that, yeah, they can certainly find whether a person has been a bad boy or not. I think that's what's happening. But that doesn't bar other teams or other parties from filing claims against Crane and the Astros.
See, but I think it might. Follow me on
Well,
this.
but go ahead. I'll hear
My
you.
curiosity would be, if from a settlement perspective, you know that Major League Baseball and the commissioner's office are cast as the agent to act on behalf of all of the other teams. Just like in the NFL, Roger Goodell
Mhm.
is the authority to act
Right.
on behalf of all the owners. and administer justice for the owner, same way you would in Major League Baseball. Does the actions taken by the commissioner ultimately then bind all of the other teams? See, I think it ultimately ends up being a situation of contract law with all of the teams' agreement to become a member of Major League Baseball, and what rights do they then give to the commissioner to operate on their behalf? See, the thing is, my curiosity would be, how do the fines that they pay to Major League Baseball ultimately get redistributed as almost damages to the other teams as part of like a settlement agreement?
In that case, yeah.
Because to me,
Yeah.
like, that's what the arbitration
Right, correct. But I don't know how. I mean, we look at other bodies, like we look at OSHA, we look at whether that's admissible, whether that goes to the weight of, and whether it comes into a real court of law. Some courts say yes, some courts say no. We fight about that all the time. Trust me, I want OSHA violations to happen all the time. But I think you're right. I think that if that money in penalties gets distributed as damages to the potential parties that would have claims, it smells like that would be the case, right?
See, my curiosity
because they're being remunerated for it.
What I would be very curious about is from a player's perspective. Okay, let's say Jose Altuve wins MVP that year. Okay, and let's say, for example, who finished second that year? I can't remember.
Was it last year?
2 years ago?
Oh, the Dodgers.
3 years ago?
LA.
No. Who came in second in MVP voting the year that Altuve won it? So here would be the scenario where I would be very curious. Altuve wins MVP that year. It's a year where there's sign stealing. As a consequence of the sign stealing, he hits nearly 400.
Right, ridiculous.
You finish second in the MVP voting, and you lose X in endorsements, you lose X in compensation, you lose X in bonuses. That person potentially has two things. I think they would have a claim against Altuve personally and against the Astros for vicarious liability.
2 years have passed.
But are they governed by
a new toll? Yeah. If the finding is that,
discovery period?
yeah,
discovery
then there's a 2 year statute of limitations. It would be told in from the finding that there was a fraud committed, or there was, it's actionable.
Yeah.
So I think that's a huge damage model if you think about it, because
fucking great.
you would have to find then an expert that says, whoever came in second that year, that if he would have been MVP, then his earnings would have gone up by 50 million or 30 million a year, and therefore it's a big damage model. It's an interesting question, actually.
That's my favorite question we've ever gotten, that I thought was elementary, but I think in turn is, because I'm not sure that there's not some antitrust component to
there
a
could
certain
be.
extent.
That's actually right. There could be. Yeah.
But anyway, okay, so we've been told to wrap it up. We became enamored with Justin Kirk and his
Thank you, Justin.
his question, which we
Come
thought
join
was
us
great.
again. We're here tomorrow. We're here next week. So we like the sports questions.
Next Facebook. Our next Facebook is Tuesday of next week, and we'll be discussing trucking accidents, favorite topic
One of our favorites.
of Randy and I's. Additionally, Randy, who are we having next? Chris Shimbra?
Yeah.
Tomorrow.
Yeah, tomorrow on Instagram Live at
of course,
4, we have our good buddy Chris Shimbra, who will be giving a couple of books away. But the topic tomorrow is going to be gratitude, which I think we all need right now. It's a tough time. I think that people are, going time jobs. People are at home. They're depressed. The walls are kind of closing in on you. Sometimes it feels like it's a glass is half full sort of situation, or glass is half empty, full. But anyhow, we'll be talking about gratitude tomorrow. So please join us, because I think it'll certainly be worthwhile for many of you that are at home not doing anything anyway. You've already run out of Netflix. You've seen Tiger King 50 times. So join us. Oh my God, it's amazing. Amazing. I binge watched it.
Nikki asked me about it
2
last
weekends ago. It's incredible. It's interesting. You're going to ask them.
And if you haven't checked out Ozark season 3 yet, please be sure to do so. It's fantastic as usual.
Yeah.
Anyway, Facebook Live, right? Tomorrow? Or is that
Instagram
Instagram Live tomorrow, 4
next
p.m.
Tuesday is Facebook Live again.
Chris Shimbra at 4 tomorrow, discussing gratitude. And he'll be able to give us a New York coronavirus report as well from the big city. straight into your homes in Harris County and around the world. Have a good night.
Thank you guys. Appreciate it.
Signing off at Patrick Daniel.
Mhm.